Thank you. So this meeting is an informational session on the department's Division 10 Critical Groundwater Area Designation Rules. I'm going to go ahead and bring up a PowerPoint now to share with you guys. And is that full screen there? Are you seeing the presenter view, which is full screen?
No,
We're seeing your notes.
The notes. Let's see if I can. Stop share here. I'll go ahead and share my screen too instead. Is that working for folks? And take a minute here.
Yes.
yes, looks good.
Perfect. Okay. So this is our meeting agenda for today. We've stepped through sort of our preliminary introductions, and we're going to be getting into the presentation portion of this meeting now. I've set aside basically an hour to go over the governing law and draft rules, and also an overview of the rulemaking process in general, some steps of how you can engage, and also like what are the next steps for this rulemaking. Then we're going to be going into breakout rooms. I would note at this point that if you are not interested in providing questions or comments, you aren't required to stay for that portion of the meeting, but this is an opportunity for some additional public engagement and for us to get some feedback from folks on this call about the draft rules and about the rulemaking process in general. So a couple community guidelines before we get started. I would ask that we treat others respectfully. And if you are not speaking, please remain muted. If you are joining by phone, you can mute by pressing *6 to mute or unmute yourself. You can also use the raise hand feature to indicate that you would like to speak. This is primarily during the breakout room session. And you can also do this via phone by pressing *9 on your keypad. Finally, we would ask that you hold all questions and comments until the breakout room portion of the agenda. Oh, sorry, I didn't have that slide up for you guys. I apologize. So I'll pause there for a moment so you have a chance to take that in. And then we will move on to addressing questions. This is kind of how we would like the meeting to go. So if you could hold your questions until the end at the breakout session. If you have questions throughout the presentation, please write those down. You will have a chance to provide a list of your questions to the staff facilitator in the breakout room. They're going to be capturing everyone's questions and writing those down in a shared Word document. And then we will be answering as many of those questions as we can during the breakout rooms. We might not be able to answer all of your questions at that time, but we will be following up with folks after the meeting if we don't get to your question. Okay, with that, we are going to be moving on to the bulk of this presentation, which is an overview of the governing law and draft rules. So starting out with what is a critical groundwater area? And this is captured by the acronym CGWA. And this is a critical groundwater area is a designation which is authorized under Oregon Revised Statutes Chapter 537, Section 730 to 742, which allows the Oregon Water Resources Department to take corrective actions that are necessary to address groundwater supply, quality, or thermal issues. And these actions may include but are not limited to closing the area to new uses or limiting, excuse me, can't speak today, existing uses of groundwater within the area. A critical groundwater area designation is the only control that authorizes corrective controls. the only groundwater control that authorizes corrective controls or curtailment of existing groundwater uses, and is the only groundwater control that authorizes curtailment of groundwater uses to protect senior surface water users. So a little bit of background and history on critical groundwater areas. The first critical groundwater area was established in 1959. This was in Malheur County. And since that date, we've had 6 other critical groundwater areas that have been established. The statutes that govern this process were amended in 1991, and the department's rules were last updated in 1990. So they do not reflect the changes to governing law that occurred in 1991. So why is this rulemaking needed? The existing Division 10 rules reflect those prior statutory processes, and they do not conform with current law. So it's necessary for the department to update these rules to ensure they conform with the statutory process for designating a critical groundwater area. These proposed rules will also clarify statutory terms and processes and establish a framework to guide future basin or subbasin specific critical groundwater areas. These are some things that the rules will address. So the purpose of the proposed Division 10 rules is to guide implementation of the critical groundwater area statutes, which are contained in Oregon Revised Statutes, Chapter 537, Section 730 to 742. The proposed rules will primarily focus on updates to conform to statute, and they cover relevant definitions, the required criteria for critical groundwater area designation as specified by statute, the critical groundwater area rulemaking process requirements and rule content, filing, and review requirements, which are specified by statute, the consultation process with affected local governments, the notification processes for establishing corrective control provisions, and the contested case process for corrective actions. These rules will not create basin or subbasin specific critical groundwater areas, nor will they limit groundwater appropriation or implement corrective control provisions. The purpose of the proposed Division 10 rules is to guide implementation of the critical groundwater area statutes. So they will not be establishing any particular critical groundwater area, but it's more about the processes around establishment. So moving into our statutory framework, I'm just going to briefly kind of summarize and step through these 4 different statutes. The statute listed here is Section 730, and this authorizes the Water Resources Commission to designate a critical groundwater area if certain criteria are met. Sorry, just a moment here. Lost my place on my notes, I apologize. Okay, here, the criteria. So I'm just going to read these out. These are what is in the statute of what has to be found before the commission can begin rulemaking to designate a critical groundwater area. So the department, if the department finds a pattern of substantial interference between wells within the area, or if the department finds a pattern of interference or potential interference between wells in the area with the production of geothermal resources from an area that is under regulation under Oregon Revised Statutes, Chapter 522. If the department finds a pattern of substantial interference between wells within the area and a senior surface water appropriator, or substantial interference with a restriction on surface water appropriation that has an earlier effective date. Additionally, if the available groundwater supply in the area is being or is about to be overdrawn, or if the purity of the groundwater in the area has been or reasonably may be expected to become polluted, or if groundwater temperatures in the area are expected to be, are being, or have been substantially altered. So one of these 7 criteria must be met for the Commission to designate a critical groundwater area by rule. This section also authorizes or also requires the department to follow the normal rulemaking process, with the exception that a hearing must be held on the critical groundwater area designation at least 60 days after notice is given. Excuse.
Sorry about that, folks. It sounds like there's a dog in the background that has decided to crash this public
He's
presentation.
decided it's his time to go out for a walk. I apologize, folks. I am home alone, so I have no one else to make him be quiet, but hopefully he will bear with us here.
Hey,
Okay,
Breeze,
moving on.
Breeze, as long as we're
Go ahead.
you're a couple slides behind your talking points.
Oh, I apologize. That looks, so this is the slide relevant to the talking points. Or Justin, I apologize. So we're talking about section 730, and we were discussing the criteria required under 730 for the Commission to designate a critical groundwater area. So moving on to, are you seeing section 735 on your screen?
Yes, I am. Thank you.
Okay, perfect. So this section outlines the rule requirements for a critical groundwater area rule, and this includes a definition of boundaries of the area, and it must also contain a provision requiring periodic review of the area in order to determine its continued need. Finally, section 735 authorizes the Commission to include 1 or more corrective control provisions in the critical groundwater area rule. So I do have a slide listing these off. These are separate and distinct from the corrective control provisions, which are authorized after the contested case proceeding, which occurs under 742. So these are the corrective control provisions that the Commission can include within the rule during the rulemaking process. These include a provision which closes the critical groundwater area to any further appropriation of groundwater, a provision determining the permissible total withdrawal of groundwater in the area, a provision that disposes of any application for a water right permit for the use of water in the area that is pending at the time the Commission initiates the rulemaking process or that is received during the rulemaking process. Any 1 or more provisions that make additional requirements as necessary to protect the public welfare, health, and safety in accordance with Oregon Revised Statutes Chapter 537, Sections 505, 795, and 992. A provision closing all or part of the area to further appropriation of groundwater for its thermal characteristics, and a provision determining the permissible change in thermal characteristics of groundwater in all or part of the area. So these corrective control provisions, as I mentioned, are different than the corrective control provisions we'll be talking about in the next section. Ken, I do see you have a question. I would ask that you hold that question until the end of the presentation, unless it has to do with the flow of the presentation here. Thank you. Please be sure to note down your questions, and that's going to be the purpose of our 45 minutes in the set aside for the breakout rooms. So the statutory framework has 2 additional statutes here. This is Statutes Section 740 and 742. 740 is pretty simple. It just requires the Commission to file a copy of the critical groundwater area rules with the county clerk of each county that lies within the proposed critical groundwater area, and requires the clerk to record the designation and the deeds of the county. Section 742 is the section that relates to the contested case proceeding process. And this authorizes the Commission to initiate a contested case proceeding in order to limit use of groundwater in the area if the Commission has reason to believe any of the criteria which I talked about in Section 730 exist. This step can only occur after the Commission has adopted a rule designating a critical groundwater area. So Section 742 requires the Department to follow the contested case process, which is outlined in Oregon Revised Statutes, Chapter 183. And then upon the conclusion of the contested case proceeding, and upon a finding that no problems which resulted in the designation of a critical groundwater, and upon a finding that the problems which resulted in the designation of a critical groundwater area can be resolved by implementing one or more of these corrective control provisions, the Commission is required to issue a final order establishing any one or more of the corrective control provisions. So these corrective control provisions are the ones that occur after the contested case proceeding. And sorry, I lost my place here. I apologize. Here is a list of them. The provision apportioning the permissible total withdrawals established by rule under Section 730 among groundwater appropriators in the area in accordance with their relative priority dates. A provision according preference without reference to relative priorities to withdrawals for groundwater in the area for certain purposes. A provision reducing the permissible withdrawal of groundwater by any one or more appropriators or wells in the area. A provision adjusting the total permissible withdrawal of groundwater by an appropriator that has two or more wells in the area, or a provision forbidding the use of one or more wells completely. A provision requiring the abatement in whole or in part or sealing of any well in the area responsible for the admission of polluting materials into the groundwater supply or responsible for the impairment of the quality of groundwater supply, or a provision requiring and specifying a system of rotation of use of groundwater in the area. So these are the general provisions of the statutes that govern the establishment of a critical groundwater area. Our proposed rules will repeal existing provisions that relate to those prior statutory processes and replace those with new provisions that conform to the current statutory process. So the new rules are listed here. I've broken them out into two main categories, sort of similar to how we talked about the statutes. Those relate to new provisions that relate to the critical groundwater area rules and the rulemaking processes, and new provisions that relate to critical groundwater area corrective actions and contested case proceedings. So this is just a list of the proposed rules here. I kind of grouped them together. So this is sections 100 to 150, which are represented by these bullet points, which I'll expand on a little bit further here. The purpose of the Division 10 rules is to guide the implementation of the critical groundwater area statutes. And the proposed rules incorporate the definitions from the Department's Division 8 rules, which relate to statutory groundwater terms. The Division 8 rules define a number of terms which are used in the criteria for designation of a critical groundwater area. Under Oregon Revised Statutes, Chapter 537, Section 730, such terms as decline excessively and substantial or undue interference. The proposed Division 10 rules also define several additional terms which are not defined in Division 8, such as affected local government, groundwater reservoir, and water right. The proposed rules incorporate and clarify the statutorily required criteria for designation of a critical groundwater area that are contained in Oregon Revised Statutes, Chapter 537, Section 730 that we discussed. And the proposed rules also provide further guidance surrounding the additional rulemaking requirements related to critical groundwater area designation rules, such as notice. So prior to holding a Rules Advisory Committee on critical groundwater area rules, The department is required to consult with the affected local governments and provide them with certain information to assist with consultation. So the rules provide additional information about that consultation process and also incorporate our Division 5 rules, which are our local government coordination rules and land use planning rules. Additionally, the proposed rules incorporate and clarify the content, filing, and review requirements that are outlined in statute. This next section of rules, 160 to 220, are the rules that relate to the contested case proceeding process. This process includes an initial notification of proposed corrective actions, which must include an identification of the critical groundwater area at issue, a statement describing the factors that led to the critical groundwater area designation, a description of the proposed corrective actions, a description of the geographic area where those actions will be proposed, and a description of how persons may request a notice of proposed corrective action. The proposed rules also cover what is required to be included in the notice of proposed corrective action and the process for notification. The proposed rules provide a process for requests for party status, define the scope of the contested case hearing, and describe the conduct of the contested case hearing. There's also a section which provides for exceptions to the proposed order and outlines the requirements that must be met for those exceptions to be considered. And finally, the proposed rules describe the process for issuance of a final order and what that final order may contain. We do have the draft rules posted on our website. That's accessible on our rulemaking page, and you can kind of step through and see the first part of the rules will be all crossed out. That's our repealed sections. And then all the underlined sections are the new language that relates to these slides that I've been discussing here. Okay. We're going to move on to an overview of the rulemaking process and how you can engage and next steps. So as a general overview of the rulemaking process, administrative rulemaking must follow the procedures of Oregon Revised Statutes, Chapter 183, and the Attorney General's Model Rules and the Department's Division 1 rules. So our rulemaking process begins with internal development of draft rules. We then appoint a Rules Advisory Committee, or a RAC, and this is comprised of persons likely to be affected by the proposed rule change. The RAC provides the department with feedback on the substantive language of the rules and any fiscal impact that may result from the proposed rule change. The next step, and that's the current step that we are in, is this development of draft rules and the Rulemaking Advisory Committee. The Rulemaking Advisory Committee will be meeting tomorrow. That will be their first meeting. So we're really at the very beginning of this rulemaking process for these Division 10 rules. The next step of the rulemaking process is notice of proposed rulemaking. This is filed with the Secretary of State's office and includes information about public hearing and public comment opportunities, the proposed rule language, and a fiscal impact statement. This is published in the Secretary of State's bulletin, and it signals the commencement of the formal rulemaking. The department also provides notice to legislators, interested parties, the media, and the public to ensure those impacted by a proposed rule change are notified of their opportunity to comment. And I do have some information upcoming about our rulemaking listserv, and that is one way to stay in the loop about rulemakings that have gone to public comment. Once the public hearing is held and the public comment period is closed, the department staff prepares a staff report. We look through all of the comments we've received, make adjustments to the draft rules as necessary, and present a rulemaking recommendation to the Commission for consideration. The Commission then decides whether to adopt, amend, or repeal the rule. And once they do so, we file those changes with the Secretary of State, and that appears in the bulletin as a permanent administrative order. So our rulemaking timeline for this rulemaking is pictured here. As I mentioned, we are currently in the rule development process. So we're in that first stage there. And we expect to hold several RAC meetings throughout the beginning of this next year in order to develop the draft rules. And those will be what will go into the Secretary of State notice, which we are anticipating filing either in March or April of next year. Following that publication and the public comment period and public hearing, we will be considering all of the comments that have been received and developing our recommendation for the Water Resources Commission. That will most likely be occurring in May, and then the commission meeting is in June, and they will be hearing that staff report and recommendation and making a decision on these proposed rules and whether to adopt them. So we've got a number of public engagement opportunities. Since we are really at the beginning of this rule development phase, there's several chances for folks to provide feedback on these rules and ultimately influence how the rules look. So I've listed here the Rules Advisory Committee meetings. These are public meetings that you are welcome to attend as a member of the public. We ask the RAC itself is there to give direction to the department and to provide feedback for our development of the rules. So they have their discussion during the meeting. That's the main part of the meeting. And then we have provided a public comment opportunity, which will be at the end of every RAC meeting for 30 minutes for this upcoming RAC meeting. And that will be an opportunity for folks to provide oral comment or provide written comment at the end of the meeting regarding the draft rules. We will also have the public comment period and public hearing, as I mentioned previously. That's part of the sort of formal rulemaking process. Once the rules are noticed in the Secretary of State Bulletin, there will be information about how you can comment, either written comments, which need to be submitted by a certain point in time, or by attending the public hearing, and you can provide oral comments at the public hearing. So how can you stay engaged? You can sign up for our rulemaking listserv for updates. There's more information about how to access that in our handout. You can also visit our website and navigate to it there. We also have listservs for other department notices that you can sign up for at the same time. You can also contact me if you have questions or feedback or need more information. And as I mentioned, you can attend and listen to the RAC meetings. That's another great way to stay in the loop on the development of these rules and provide feedback. So next steps, as I mentioned, we're in the Rules Advisory Committee phase. The first meeting is tomorrow, December 17th, from 9:30 to 11:30. We've set aside the last 30 minutes for questions and comments from the public. We will be having a minimum amount or a maximum amount of time that folks can comment based upon the number of folks who sign up to comment or attend and indicate they would like to comment. We will be working with RAC members to get meetings scheduled in January and February. And we may also have a meeting in March depending on our progress through the draft rules. So at this point, we're a little ahead of schedule, but we would like to go ahead and transition into our breakout rooms. This is an opportunity for you to ask questions and provide feedback on the proposed rules in the rulemaking process. And if you don't have questions or feedback at this time, you can feel free to sign off from the meeting now if you would like to. For those of you who would like to participate, we're going to be sorting folks randomly into breakout rooms. You'll be in rooms of no more than 10 folks with a staff facilitator. And we'll be asking you to write down your questions. And then the staff facilitator will be kind of going around the room round robin to have everyone list out their questions, and they'll be capturing those in a Word document. And answering as many of those questions as they can. We have some staff who are subject matter experts who will be floating between these breakout rooms to assist in answering questions. And then we will be, hopefully, now that we're a little ahead of schedule, we'll have some time for some additional feedback, which we would ask you to write down, and we'll be capturing that similarly. And if we run out of time for any of these steps, you're welcome to send your feedback to me, or if you have to jump off this meeting early, you're welcome to send your questions or feedback to me, and I will follow up with you. So at this time, I'd like to pause and see if any of my staff facilitators have anything to add before we move into the breakout room session.
Breeze, do you want to move to your contact slide just to share that information?
Yes. So I think we are, if you bear with us, we gotta wait for a moment here for Nirvana to get our breakout room set up.
Okay, Breeze, I'm going to go ahead and stop the recording.
Okay.
Hang on here. And now I want to